Yes, go ahead.
Yeah, Kenya is a constitutional democracy, and the powers exercised by any state officer or public agency is spelled out in the law, and to that extent limited by the law. So all state agencies and functionaries, including the president, exercise powers which are donated by the Constitution or statute. In this regard, to stop abuse of exercise of decisions, particularly that of the president, it was required that under Article 135, that any decisions made by the president must be in writing and shall bear the seal and signature of the president. This is for good order. What happens when that does not happen? When it does not happen, then we have a situation like we are presently faced with in this matter, where the president made a speech and directly spoke to matters which are now before the court and what was to be done. And on the date he spoke, on the 6th of March, things were already happening. And then on the 16th of March, that is covered by an affidavit attached to the supporting affidavit to the petitioners, Mark GN 3, no, GN 2, which is a statement by the spokesperson in the office of the president on the 16th of March. On paragraph 14, he in fact says that appropriate directions were issued to relevant agencies for further action in accordance with the law. Prior to that averment, he actually talks about which agencies these are. And notably, it includes the Directorate of Criminal Investigation, the Asset Recovery Authority, and the National, the National Intelligence Service. And part of his statement was remove and charge. That word alone speaks to a power that the president doesn't have. And it has shown that some of the petitioners have actually been arrested and charged. And to characterize the abuse of process, charges are preferred, accused persons appear in court, and then immediately there's an application to withdraw under Section 87A of the Criminal Procedure Code. Now, it is not by coincidence that after the president's statement, all these agencies rushed to deal with this matter. It is not a coincidence. And in the center of all this is the Director of Public Prosecutions. Because there's an arrest and charge of some of the petitioners, and the Director of Prosecution elects not to respond to factual averments contained in the petition and in the supporting affidavit. Mr. Kubas has referred to the affidavit by a police officer. That police officer does not depend that he has the authority to make those statements on behalf of the Director of Public Prosecutions. Now, there's a case we have referred to which I wish to just comment on, the case of Hassan Ali Joho versus the Inspector General. It was a judicial review petition number 15 of 2017 in Mombasa. Very similar circumstances. The former president made utterances in Mombasa saying that he was going to, in Swahili, kumnyorosha, the word that was used, the governor then of Mombasa. And my Lord, when you look at the judgment, a similar situation occurred that after the president made those utterances, all the agencies, including the ones which have been mentioned in this court, got into motion, including KRA, DPP, DCI, all of them. And the judge makes a comment that probably the president didn't mean what he said. But holding that office made several agencies to act on his behalf, so to speak. And that's why I'm saying Article 135 is very important. When the president makes a decision, it must be in writing and bear his seal. Otherwise, a lot of people can do things in his name. But the long and short of it is that Governor Hassan Ali Joho was charged and prosecuted. And that prosecution was brought to an end by intervention of the court. The president shouldn't have been seen or to be understood to be given direction, particularly the Director of Public Prosecution. Yet in his statement, it's quite clear that he wanted the petitioners charged, and they were charged. But I leave it to the court to look at this judgment. I think it covered many of the issues that are before this court. And it was an absolute abuse of power and process, and constituted various violations of the Constitution as we spelled out in our petition here. So I also join my colleagues in saying the orders prayed for should be granted. And I wish to say from the bar, I don't know whether your Lordship you're aware of this famous Archbishop of Canterbury. There's a book about the murder in the cathedral. And the Archbishop was murdered because the monarch uttered words in which his officers thought.
You're referring to Thomas Becket?
Thomas Becket, yeah. Quite right, quite right. They just thought the king meant that this man should be killed. And I'm afraid in having participated in the Dr. Uko's trial, again, that murder could be explained by utterances which were misunderstood or were understood and then led to very tragic consequences. Hence, Article 135, that since there's no evidence that Article 135 was complied with, then it means that the utterances by the president was a mere statement, probably a political statement. That is being said in ignorance, or with respect to ignorance to the powers of the president under Article 131 of the Constitution, which we are referred to in the petition. It is not just anybody. He is required to respect, uphold, and safeguard the Constitution. Ensure the protection of human rights. So when the president is saying something that is outside his powers, do we then take it that because he has not put his decision in writing, that he can get away with it? I think it's an unfortunate argument in a constitutional democracy. The president is not a monarch, he's not an emperor. He cannot make any statement that he wishes, if you look at Article 131. And I'm also astounded, if you look at the Dunguru case, which unfortunately my learned friends did not refer to. What Justice Madan was accusing Chunga of doing is exactly what they are doing. That the accused, or rather the respondents, in obedience of the summons, they can just appear. That's what the law requires. They can go to court and defend themselves. There's a procedure. And Justice Madam said that even the very fact that somebody has been summoned, that person who answers to a summons and appears before a police officer is somewhat shredded and shorn. Kenyan policemen are not angels. Just that appearance is what Madan was saying. You know, summons are not an invitation to dinner. And then he said, what sort of a madman would wait to be summoned, to be charged, to be tried? I think this statement rings very loudly, even now when we have the kind of constitution that places human rights as an integral part of the Kenya's constitutional democracy. The Bill of Rights is at the center of the republic as established in Kenya. That's why even a mere threat to a violation of the Constitution gives somebody a right of action. And finally, There are amendments which have been made in the petition and in the supporting affidavit, putting the 8th respondent, that is KRA,
Yes.
at the center of this activity. Not to mention the press statement by this government spokesman, where they're part of the agencies that were being made to resolve this issue at Nairobi Hospital. I should have been happy if, in answer, they were saying that when they read that statement, they wrote a letter to the spokesman and telling him that they have no role. This is a public statement. But they didn't. And then paragraph 66 of the petition says simultaneously the 8th respondent has commenced tax assessment and enforcement proceedings against the petitioners. That is supported by the supporting affidavit. There has been no denial in a pleading. So this talking from the pulpit, as it appear that tax assessments are done in regular fashion. There are days to answer. You know, so many people commit suicide out of these tax assessments. Yeah. People don't pay taxes because they are giving sadaka in the church. It is something that you're obliged to do against your wish. And this statement is made in the petition and the replying affidavit. There's no response to it. And what is being said is being said from the bar. And then finally, you know, this petition has appeared in court. Not only appeared, were arrested and appeared in court, only to be told that you cannot plead to the charges. I mean, what type of institution is that? And some of us were there. We spent the whole day from 8 o'clock in the morning to 3:30. Somebody was kept in the car for 7 hours. Yeah, and the person died eventually. As I said, when you are caught up by KRA, you are very near the grave. So, Your Honor, from all that has been stated, this is a case where the court really would not have an alternative but to give the orders prayed for. And it also counts that even ex parte the court issued those orders just by looking at the petition and hearing the petitioners. And is this court that make institutions be what they should be? If they're allowed to do things in their own way, we will not have a republic. That's why these courts are there. So I urge you to give the orders. That's great. Thank you.
So ruling on 2nd of July 2026, interim orders extended until then.
Much obliged.